Step 6. Pre-hearing conferences. In the family court, there are a series of pre-hearing conferences that are designed to help facilitate settlement, narrow the issues, and figure out what the case strategy is going to look like. A resolution management conference is an RMC. It's typically scheduled when there's attorney, sometimes if there's no attorney. A resolution management conference is about half an hour. You have to file a resolution statement prior to this. You can get that form on the Maricopa County Superior Court website. You want to be pretty specific in your resolution statement about exactly how you'd like the case to be resolved. You can't do a good RMC statement without the information that you gathered during discovery. How do you know how you want to specifically split the assets if you don't know exactly where they are, or exactly who owns them, or exactly what the terms of the interest rate are? That's why discovery's so important. The resolution management conference is a half an hour. It is in front of the judge that is assigned to your case at the courthouse. One quick thought on this: you have the ability to change your judge once as a matter of right before you go in front of the judge. If you are assigned a judge that you do not want for your case, you need to file a notice of exchange of judge before the RMC. At the RMC, you tell the judge how you want things to move forward. Not only do you tell them how you want the substantive issues to be resolved, for instance, I want Joey to go to X school, or whatever kiddo issues you have going on, or money issues, but also, do you want certain experts appointed? Do you want to go to a parenting conference? Do you want to go to an ADR? Do you want a comprehensive family analysis? Do you want a drug testing for the other party? What sort of things do you need the judge to order? This is the time to ask. An early resolution conference is different. It is set with conciliation services. You go in front of the third-party mediator. It's you and the other party. Usually this is set when there's no attorneys, but sometimes attorneys get to go. One time I got to go, and I was able to really help my client facilitate a fantastic settlement. It's set for 3 hours. It's different from an RMC. You're not in front of the judge and you don't have to file a RMC statement in advance, but you're gonna want to bring your evidence, because that's gonna help you negotiate. An ADR stands for Alternative Dispute Resolution. This is usually a judicial settlement conference. This is a 3-hour conference that is assigned to, not your judge, but a judge pro tem. They are usually an attorney or someone who has a lot of experience in family law. Their job is to help facilitate the settlement. Before you go to the ADR, you submit a confidential memorandum to that judge pro tem outlining all of your positions. This is like your pretrial statement. You are going to want to have all of the information that you need going into it. So again, this is why discovery is so important. The other pre-hearing conference that you might get is a return hearing, or as a status conference. That is a little more loosely defined. Sometimes they take evidence, sometimes they don't. It's just an opportunity for you to talk to your judge. Sometimes it's telephonic, sometimes it's in person. Kind of come up with an idea of what's gonna happen. Maybe you're gonna set a case for trial, maybe you're gonna go over the remaining outstanding issues, etc. etc. Pre-hearing conferences are designed for a lot of different purposes, and we just talked about those. But the other thing to consider here throughout all of this is negotiations. You should make a good faith effort to look like you are negotiating. It's important. If you don't, you are exposed to paying the other party's attorney's fees. Unless you're in a position where you are afraid of the opposing party, you should try to engage in negotiations as much as possible. With that being said, there is many ways to do it. If you are afraid of the opposing party, you can engage in negotiations in writing or via attorneys. You don't have to do it yourself, it doesn't have to be in person. And when we do mediations or ADR, alternative dispute resolutions, or judicial settlement conferences, we can absolutely have the parties be in different rooms where they never see each other. Another option is that one party, shows up an hour earlier than the other party so that you're never ever seeing each other. It is absolutely an option.